I want to thank you again, Matt, for joining us. This is the Pennsylvania Institute of Certified Public Accountants, CPA-PAC. I'm Peter Calcara, Vice President of Government Relations. We want to welcome Matt Wolford to be with us today. Appreciate your opportunity. Matt is a candidate, Republican candidate for Commonwealth Court. Just a real quick background on PICPA. So PICPA is the second oldest and fifth largest CPA organization in the country. We represent 18,000 members from across the spectrum: public accounting, business and industry, government, and education. We use these platforms, these discussions, if you will, to allow candidates for judicial offices to kind of really just do kind of a meet and greet with our membership. We don't get into, legal analysis or anything that. It's really kind of an informal, high level, who you are, why you're running, that kind of thing. It just gives a different perspective. It allows our members to kind of see who you are, and if they want to do more, a deeper dive, there's a number of different platforms they can do. So that's what the goal is today. So again, Matt, welcome. I will kind of open it up. I know we only have a half hour. Kind of open it up and just tell us a little bit about yourself and why you're running for Commonwealth Court.
Sure. So I'm from Erie, Pennsylvania. I've been a lawyer for 38 years. I'm from Erie originally. I went to Penn State undergrad, and then I went to Temple Law School. I did not plan on coming back to Erie back in those days, and started working for the Attorney General's Office Torts Litigation Section as a way of learning how to do civil litigation. So as a Deputy Attorney General in Philly. And I was doing that for a few years and really learned a lot about how to litigate. As you can imagine, in the Philadelphia Court of Common Pleas, it's quite a court system. We also had the surrounding collar counties. So I did that, and my dad died, and I was driving home to Erie to help. My mom was just managed her affairs, and it occurred to me a few months into that maybe I need to transfer back west in order to help out, because the drive is, as anybody knows that's from Philly, how far Erie is, and vice versa. So I transferred. A job that came up in the AG's office was environmental crimes in Meadville, Pennsylvania. So I transferred and became an environmental crimes prosecutor in Meadville, PA, which is about 40 miles south of Erie. And then I learned there how to do criminal litigation. So at the AG's office early in my career, I learned both civil and criminal litigation. I got interested in the environmental aspects of what I was doing in environmental crimes, and decided that I wanted to learn more about it. Environmental work is mostly administrative type stuff. It's mostly civil, a lot of regulatory permitting, that sort of thing. So I took a job with what's now called the DEP, the Department of Environmental Protection. I was with them for 4 years as an assistant counsel. I was the water lawyer for the Northwest region, which was also the oil and gas lawyer back in those days. And then I was ready to leave government service, and they promoted me to being in charge of that office. So I was what they call regional counsel. So I was one of 6 regional counsels statewide. I did that for about 3 years, and then I left government service. I opened a private practice in Erie, Pennsylvania, back home. I met my wife along that time frame, and she wanted to stay in Western Pennsylvania. So that's kind of how we ended up back in Erie. And so I started my private practice, and that's been 25 years now. Small business, solo practitioner. Much of my work is litigating against the DEP. I still, practice primarily environmental law. I also do some other stuff, zoning, some eminent domain, easement disputes, things like that. But most of my work is litigating against the DEP. And let me explain that a little bit too. When people hear that, they're like, "Well, you always litigate against the DEP." The way that the administrative law system is set up in Pennsylvania is that you have to litigate with the DEP in order for you to have any negotiation leverage. What happens in Pennsylvania is that if the DEP takes an action, say an order or an assessment of penalties or something like that, you have 30 days to appeal it, or it becomes administratively final. And if it becomes administratively final, you have no negotiation posture at all, because everything's final. And so what you do instead is you appeal it to the Environmental Hearing Board, and then you can either litigate it or you can try to resolve it through negotiations. And most of my cases get resolved through negotiations because you now have leverage that you would have lacked had you not commenced litigation. So it's a little bit of a misnomer to think that I litigate against the DEP all the time. A lot of times, technically, that's correct, but we're trying to find reasonable solutions that the government can live with in terms of environmental compliance, and my clients can actually do that it's economically feasible. So I've been doing that for about 25 years, and I'm interested in the Commonwealth Court. This is a court that I've been in front of since the early days of my career. I had my first appeal to the Commonwealth Court in 1988, my first oral argument in 1989. DEP actions that are unopposed. I was just describing, if you don't file an appeal to the Environmental Hearing Board, those go typically to Commonwealth Court. If you do file an appeal to the Environmental Hearing Board, those go through trial in that agency, and then they go to the Commonwealth Court. So I've been in front of the Commonwealth Court on both sides of the fence for a long time. I enjoy appellate work. It's intellectually stimulating. I always have, and so the Commonwealth Court is mostly an appeals court. And in addition to that, I have some concerns that I've noticed over the years practicing in front of this court. I think I've seen it over the 3 decades plus that I've been practicing that it tends to side with government more and more and more. And that concerns me. So if you think about the kinds of cases that it has, eminent domain, right to know law, election cases, zoning, that sort of thing, it's always about the government, state and local government. That's what this court does. And as a result, it does a lot of regulations. It deals with regulations all the time. And the regulations are when the government, break it down, they either tell you what you can do or what you can't do. That's what a regulation is. And it's the antithesis of personal freedoms and private property rights. And I'm a proponent of personal freedoms and private property rights. And so, a certain amount of government we need. We want good roads, we want fire protection, we want police protection, we want clean air, we want clean water. But overreach and overregulation is unnecessary in my view, and really kind of hampers the economy. And when I was regional counsel, was under the administration in the 90s, we were actually trying to roll back on some regulations and sort of have a different way of doing things. This was under Secretary Seif, and we were about obtaining environmental compliance while not being unfriendly to business. We're trying to accomplish both, and I think they can both be accomplished. But this is the court that deals with those kinds of issues when the government is taking an enforcement action, or someone's trying to clarify what their rights are vis-a-vis the government. This is the court that deals with that, and so I think it's, in my view, the most important court Pennsylvania has. Well, so that's my interest in the court.
It also deals with tax matters.
It does.
Decisions from Board of Finance and Revenue that are not decided there are appealed to the final level in the process is Commonwealth Court. So that's obviously an area of particular interest for us and our members. Not that we appear before the court, because we can't, but obviously up to that point, we have members that are representing clients.
I saw that. So I had heard this, and I did a little research. That structure is not unlike the Environmental Hearing Board. In front of the Environmental Hearing Board, if a corporation is a party, it has to be represented by a lawyer. And I think that's actually a Supreme Court thing. But when I heard that you folks can represent people before your department, what I found interesting is that the code, the reg, actually says unless you're trying to make a legal argument.
Right.
Just kind of, I was sort of shaking my head over that. Say, well, of course you're going to at some point be making a legal argument. So that's a pretty big limitation on you folks, other than just doing the math right. So I thought that was curious to me.
Yeah. Yes. So there's a fine line, but our members know when they're appearing before the Board of Appeals, which is in the Department of Revenue, Board of Finance and Revenue, which is Treasury. Our members are not allowed to argue. Now we do have members who are attorneys as well, attorneys, CPAs, but our members cannot argue. I guess it's at some point it does become legal, but not in all cases, not in all cases. So
Yeah, well, it's interesting because there's a spectrum there, and at some point, I'm sure you go from sort of CPA work to this looks a lot like legal argument. I don't know who's in charge of making that decision. I assume the board is. You have
the
a
board,
presiding
BF&R,
officer.
yeah,
All right.
board of Finance and Revenue. I'm curious, you mentioned the court has sided, this court has sided more with the Commonwealth in the past. Do you see that changing? And I forget the case, the U.S. Supreme Court case that kind of
Loper.
flipped that.
Yeah.
Do you see any downward influence from that in the future?
I think it's coming. So the case that you're thinking of is Loper, or some people say
Yes.
Loper Bright.
Yeah, thank
right?
you.
Yeah, that's fine. So the idea is it's Chevron deference. And so if you go back 25 or 30 years, the United States Supreme Court came up with this doctrine called the Chevron doctrine that says that the courts are obligated to defer to interpretations of executive branch agencies, which I think was wrongheaded at the beginning, and so did Justice Gorsuch. I mean, we learn in law school how we're supposed to interpret statutes. You try to figure out legislative intent. And we actually in Pennsylvania have a statute about this. It's section 1921, and then there's factors, but the idea, the main objective is to ascertain legislative intent. Well, we don't need to know what an executive branch agency thinks about the statute in order to do that. I mean, we went to law school, we can figure this out. Certainly what their view is important, but to be obligated to defer to it, I think was always a mistake. And what Loper did is it fixed that error. Here's the issue that we have in Pennsylvania, however. So in our federalist system, what often happens is the federal court system will take a position on something, as they did in Chevron, and then the states will follow suit by adopting similar doctrines at the state level. So we had Chevron in place for a long time. Now Loper comes along and dismantles Chevron at the federal level. That has not yet happened at the state level. I did some research on this a while back, and it appears that the Pennsylvania Supreme Court adopted the Chevron approach in the 1990s. And so what needs to happen now is a state court needs to also follow Loper and dismantle it. And one of the issues that's going to come up, I'm sure, at some point is Chevron applies to statutory interpretations, not regulations. All right.
Okay.
At the federal level, they also had a different doctrine. They were very clear about, well, this is a different doctrine for regulations. And if you think about it, regulations are actually promulgated by the executive agency. And so there's at least an argument there that maybe we should show some deference to them because of that. However, when Pennsylvania adopted the Chevron approach, they were not very clean about, well, this applies to statutes and this applies to regulations. It's all a mixed bag. And so I think what's going to happen is when it gets dismantled, it's going to get dismantled as a mixed bag, which I'm perfectly fine with, because I don't think that the executive agency should be dictating at all to the judicial branch how to interpret a statute or a regulation. That's my personal thought.
Appreciate that. I said at the beginning, this is more of a high level, and I kind of dove you into the weeds a little bit, so I apologize about that. But it's good to know, particularly because of the level of court. I'm just curious, why did you choose a career path in law?
Well, my dad was a lawyer, and so there's sort of a natural inclination, if that's what your dad does, that you want to follow in his footsteps. But even early on, I had this government issue. My dad was hired by a local candy maker, a guy named Herc Palakis. And Palakis had a candy store at 929 State Street. I remember the address because it's called 929 Candies, Palakis 929 Candies. Well, the city of Erie decided that they wanted that property to build a hotel. And so they eminent domain, they condemned that property. And so, Palakis 929 Candies isn't located at 929 anymore, which is sort of silly. They didn't change the name of the candies. And this was their flagship store. And, I just thought that was inappropriate. I mean, it's one thing for PennDOT to say, well, we need this property for a road. but for local government to say we need this property to put up a hotel, there was nothing wrong with that building. And so this was, for a CPA, you guys might be interested in this. So they lost the case in front of the Pennsylvania Supreme Court on the question of whether or not they could stop the taking. However, what was it worth became what the trial was about. The government wanted to pay about $125,000, as I recall, and I'm sure with the help of CPA, somebody, right? They came in at a value of $395,000 or $399,000, and that case was appealed by the city of Erie to where? The Commonwealth Court, and the Commonwealth Court upheld it. It was one of the earlier cases. That was like 71 or 72. So
Upheld for the taxpayer?
Upheld for the property owner for the
Okay.
higher value that he was given because of the
Well, that's one they
testimony
got right.
of valuation. They got it right. And I'm sure it was aided by a CPA. I'll have to go back and look to make sure it was a CPA, but I'm pretty sure it was.
Curious in your accomplishments and your work, what's has your interaction been with the CPA community?
I don't deal with them a lot. Like if I have a valuation case, sometimes I get involved. When I was at the DEP, we had a CPA on staff. People would make arguments that they lack the ability to comply, for example, and maybe they do, maybe they don't. Usually it's a financial argument. And so we would have somebody evaluate, we'd do discovery and have somebody evaluate their net worth and disposable income as well, and try to figure out, do they have the ability to comply. So we had one on staff all the time. Now my cases don't usually deal with that, but as a small business owner, obviously I deal with CPAs because they do my taxes and they help with all kinds of stuff. And so I'm generally friendly with my CPAs that are keeping me out of trouble with the IRS.
In your career, is there a single item that you'd say was your biggest or your greatest accomplishment so far?
Professionally?
Professionally.
Yeah, well, so I have several big cases that I've had over the years, and I suppose I could point to one of those, but I think probably the best thing is sort of the respect and admiration of my peers, because when I'm involved with a case, everybody around here and in the environmental community knows who I am, because I have a pretty good reputation for being a decent lawyer. And so, for example, I got the highest rating from the Pennsylvania Bar Association for the position for the Commonwealth Court. That's a big deal to me. I mean, they did an extensive investigation. They looked at writing samples and that sort of thing. And so that would be a professional highlight. But it's really just enjoying the reputation that I now have in general, I think is really the most important thing for me. Being known as someone of integrity and high quality work.
Can you share with us your view of the role of a judge and kind of your judicial philosophy? You might have touched a little bit on that now, but as a judge, you're wearing obviously a different uniform, so to speak.
Yeah. So there's lots of labels out there. You hear, originalist and strict constructionist and that sort of thing. The one that I most closely adhere to is what they call judicial restraint, which adds another layer on it. So we have three branches of government: executive, legislative, judicial. Sometimes the judicial branch wants to encroach on other branches, like if the phrase that's often used is legislating from the bench. If you wanted to be a legislator, run for Congress. But if you're not going to do that, then you shouldn't be substituting your policy for the policy decisions that were made by Congress. You follow it. And when I was a young lawyer, we used to see opinions that would say, well, here's what the statute says. We don't necessarily agree with this, but we're constrained to rule in this way. And we don't see that as much anymore. I don't see that in opinions anymore. It seems like judges are more willing to substitute their own policy preferences, which I think is a mistake. Also, obviously, you want to uphold the Constitution. And one of the things that we have at the state level, as I was saying, there's actually a statute that tells you how to interpret statutes, and we're supposed to follow it. And the pole star of that is ascertaining legislative intent. So that's consistent with what I believe to be the role anyway. And the other part of judicial restraint is sometimes courts will go out of their way to find something unconstitutional because they don't like the result that applying the statute as written will reach. Well, judicial restraint adds that extra layer by saying, if you can resolve this case without resorting to a constitutional problem, like if you can reach a conclusion without saying, is this statute constitutional or unconstitutional, you should do that. You should do that before you reach a constitutional issue. Because that way you tend to avoid having this, compromising of legislative enactments by quickly resorting to, well, it's unconstitutional, so I don't have to follow it anymore. That should be last resort. And I agree with that philosophy.
I want to open it up to any of the CPA-PAC board members. Any question for Matt? So, what is your vision for the future of our judicial system? Do you have any changes that you think if you get to the court you'd like to make?
Well, I think, we're in a very strange climate right now with all this political violence and all these other things. And I think courts that don't respect the rule of law contribute to the bad attitudes. If the courts aren't going to follow the law, why should anybody else? So I think courts should strictly adhere to, respecting the rule of law. And that means, applying statutes as written, doing the things that I was describing earlier. With respect to the Commonwealth Court in particular, I think the Commonwealth Court's been a great court, but it makes mistakes, and it interprets the right to know law in a way that favors the government, I think, more than I would like to see. These are our records; we paid for them, and so we should have greater access to them. And I say that because I have a case that deals with this. If the DEP wants to punish somebody by assessing a civil penalty and they calculate some ridiculous penalty, and you say, well, how did you arrive at that number? They don't have to tell you how they calculated it because of a Commonwealth Court decision in 2012, which I think is ridiculous. That would have never happened when I was regional counsel. If we're going to find somebody, you're going to explain how you arrived at the penalty. It seems like that's un-American not to do that. But lately in the Commonwealth Court, although they are generally speaking a very good court, they've been really slow at scheduling things, which is concerning me because, justice delayed is justice denied, as they say. And so if something takes 2 or 3 years to get through the court system, that's a real disservice to the parties on both sides, frankly. And so I would like to understand better why the Commonwealth Court is not scheduling things as promptly as they should right now, and maybe have a voice in fixing that. The other thing that I've noticed is we've been talking a little bit about when a government gets a permit application for whatever the permit might be. And in my world, it's the environmental world, but it could be any permit application. And the government agency who's in charge of reviewing whether or not it complies with the law issues that permit, which is, it's called a permit for a reason. It's the government's giving you permission to do something because you've complied with all the requirements. Those cases are treated in terms of litigation the exact same way as if the permit had been denied. You're just going through regular litigation, which can take, a year and a half in front of the Environmental Hearing Board in my world. I don't know how long they take in the department you folks deal with. And then another 2 years in Commonwealth Court, typically. So you got a permit and you can't do anything with it for 3 years, 4 years. That's crazy. So yeah. I think we need, some states call it a rocket docket. Other states have other names for it. But I was looking in the internal operating procedures for the Commonwealth Court to see if we have anything to fast track government approved permits, and we don't. And so I would be a voice for that on the court as well. I think that would be appropriate to shorten the amount of time people have to wait around after they've gotten a permit to actually proceed with the work they were allowed to do.
And that wouldn't require any legislative. That's just the court rules, correct?
I talked to the president of the chair, whatever he calls himself, of the EHB. He thinks he might need some regulation for the EHB, but I don't believe the court system does it at all. That's an internal, it's an IOP is what they call it. but the court can do that themselves.
Matt, thank you very much. Any final words for our members when they see this video? Anything you want to share why they should vote for you for Commonwealth Court?
Well, I think, summarizing, I've been around this court for a long time. 38 years I've been practicing. I've seen a lot of good judges. I've seen not so good judges. The good judges that I've seen all have a lot in common, including respect for the rule of law. That means upholding the Constitution, following and applying statutes as written, not legislating from the bench, those sorts of things. And so I would be that kind of judge. The other thing I would mention is that, again, this Pennsylvania Bar Association highly recommended rating, which, as I said, it was flattering to me. And but they did that for a reason. It's because I have a lot of experience, but it's not just experience; it's relevant experience. So the Commonwealth Court deals with state agencies. They deal with rulemaking. They deal, all the stuff that I've been doing for a long time. So I think having not only experience as being old and having litigation experience, but having relevant experience for the Commonwealth Court is important. And I'm the candidate that brings that to the table. So, and I appreciate your vote on November 4, obviously. So if anybody's get out and vote early with the mailing, do whatever you got to do, but vote. Exercise your constitutional right. It's important.
Well, again, we want to thank you for your time today and appreciate you sharing some of your views on some of these issues. Thank you very much, and we wish you the best on November 4th.
Thank you. I appreciate the time.